Order. Please resume your seats. There is an 8-minute limit on backbench contributions, but clearly you don't have to take 8 minutes. Injury time for 2 interventions, but you don't have to take any of those either. Mr. Alan Beith.
Deputy Speaker, this bill deals with 2 important issues on which the Justice Committee has reported. Sentencing was at the core of our report on justice reinvestment towards the end of the last Parliament, and it's been the subject of several reports on Sentencing Council guidelines. The Government's legal aid proposals were examined in detail in our report of March this year. The content of today's bill was originally the product of 2 major and conflicting factors: the need to respond to the financial crisis and the Lord Chancellor's determination to make the criminal justice system more effective in preventing crime and more cost-effective in the use of resources. We recognised the financial circumstances and we welcome the willingness to think radically. More recently, however, the bill did get ambushed. Some of its content and a lot of its presentation, not to mention its title, were the subject of Number 10's preoccupation with getting favourable tabloid headlines, and evidence-based policy doesn't tend to prevail in those circumstances. It's not clear, for example, that the knife crime provisions will add anything to the existing practice of the courts, which take threats involving knives very seriously, and rightly so. Personally, I'm not so concerned about the dropping of the 50% discounts, which had nothing to do with the encouragement of appropriate sentencing. The problem is that although it was unlikely ever to achieve the £100 million savings which are canvassed for it, the Department is being expected to find alternative savings to replace them. Thankfully, Mr. Deputy Speaker, the baby has not been thrown out with the bathwater. The Lord Chancellor is still pursuing his objective of making community sentences strong and effective enough to win more confidence from both the judiciary and the public. Payment by results as part of the reform of the vital work of the probation service will continue, and we will report on that subject very shortly. And we will get rid of the disastrous indeterminate sentences, replacing them with life sentences in the most serious cases. But what the bill could have done is to have begun a process leading to the commissioning of both prison and probation services by the same body at more local level. Until we do that, we will not encourage rational sentencing. Resources will not be available for things like drug treatment and intensive supervision if they are automatically taken up by the constant expansion of the prison system. And we have a responsibility as members of this House to use money effectively to prevent future crime. That's what we're engaged in. Not to give people the answer that seems the most obvious one, but actually to prevent them from suffering from crimes in future by spending money as effectively as we can. Turning to legal aid, Mr. Deputy Speaker, the committee recognises the need to contain and reduce spending on the world's most expensive legal aid system, but has serious concerns about some of the groups affected. We also suggested some alternative ways of making savings, including better court and case management and some restrictions on legal aid for judicial review. And we welcome the government's move on some aspects of that latter point. We were particularly concerned that citizens' advice bureaus and neighbourhood law centres were going to be flooded with demands for legal advice without the resources to help. And we welcome the government's initial response through the transition fund and debt advice, but more will be needed. We welcome the agreement to secure savings in the wastefully inefficient administration of the Legal Services Commission, and we agree with the wider objective of discouraging unnecessary litigation. We're glad that the government has responded to our concerns about the domestic violence definition. We think another opportunity has been missed by not taking up our recommendation on the polluter pays principle. If departments faced a financial penalty if they had too high a rate of decisions overturned on appeal, they would change their behaviour and public money would be saved. The government's response concentrates on individual cases. This is an overall thing where if departments rose above a certain threshold, where they would actually have to pay money out of their budgets. And that's the only way I think you're going to affect behavioural change and get the right decisions first time. I have an indicated area of particular concern about those clinical negligence cases in which determining liability is a complex problem, particularly, for example, children with serious handicaps arising from birth injury. Now, the Honourable Member for Huntingdon wrote to me about this and said that they were discussing with the National Health Litigation Authority and other stakeholders how the commissioning of reports could be improved with joint reports, and the Secretary of State referred to that in his reply. I have to say that in my discussions with the National Health Service Litigation Authority, I understand that that is not proceeding or is not proving to be practical. And I hope that the Minister, when he winds up, can explain what is happening on that front. And the other element in the government's attempt to deal with this problem was retaining after the event insurance for cases of this kind. But it's not clear to those who understand this system that you would actually have a viable market in after the event insurance in so narrow a field as this, when it's been abolished in other areas. Now, Mr. Deputy Speaker, the bill, as proposed, introduces some of Lord Justice Jackson's proposals, but not others. And they were a package, and if you miss bits out, there's a real danger that they don't achieve the intended effect. So, for example, yes.
Does my right honourable friend share my concern? In fact, it's concern that's been expressed on the benches opposite by the former Justice Secretary on the absence of proposals in relation to referral fees, which have been, I think, properly described as a scandal. They were a scandal at the time of the miners' compensation scandal, which resulted in 27 law firms being disciplined. Does my right honourable friend think that this is one missing part of the bill? Yes,
I do, Mr. Deputy Speaker. I was just coming to that as my final point. But I just wanted to complete the earlier point by saying that the absence of qualified one-way cost shifting leaves an imbalance in the implementation of the Jackson proposals. And it's not even clear from the bill precisely what the government is doing on this. But if I may turn to what I have myself described as the scandal of referral fees, under which insurance companies and some other bodies, such as trade unions, make money from selling on the details and claims of the victims of accidents. But it will not be enough merely to ban referral fees. The government and the industry must deal with a system of fees which has this fundamental fault. If you have a system of fees in which a lawyer can still make a profit from a relatively small claim, having paid hundreds of pounds for the privilege of pursuing that claim, then you've got to address the fixed costs as well as the referral fees themselves. It's not just these. I think I must conclude now, but I will give to the Secretary.
The reason we didn't deal with that part of Jackson was because the Legal Services Board had taken upon themselves reviewing the future of referral fees. Now, we've now got their report, and my honourable friend and myself are considering the issue of referral fees. And I take on board what my honourable friend and the right honourable gentleman making the speeches and saying.
I'm grateful to the Secretary of State. I don't think I know anybody who agrees with the Legal Services Board in the conclusions that they have drawn on this. But I hope that the matter will be looked at urgently in case the bill can be used to complete the process of dealing with what is undoubtedly a scandal and which puts up costs for our constituents. Mr. Deputy Speaker, this bill is part of a necessary process of reform in both sentencing and legal aid, but it needs a great deal of work before it leaves this House and a great deal of monitoring when it comes into force.